In the Jonesworks lawsuit, we have Docket 219. Defendants file an opposition to Jonesworks' motion for leave to amend their complaint. 1. Introduction. 8 months after the April 18, 2025 deadline set by the Rule 16 scheduling order and 2 months after fact discovery closed, plaintiffs moved to add 2 new claims against Melissa Nathan and Jamie Heath as defendant to a third new claim. Leave should be denied. Rule 16b-4 provides that a schedule may be modified only for good cause and with the judge's consent. The language of Rule 16b-4 makes clear that the court may modify a scheduling order only if there is a showing of good cause. The primary consideration in determining whether good cause exists is whether the moving party can demonstrate diligence. Plaintiffs failed to satisfy their burden to establish good cause and diligence. This court has previously recognized that waiting 6 weeks after discovering the underlying facts before taking action demonstrates a lack of diligence. There can be no dispute that plaintiffs knew the facts underlying their proposed defamation and tortious interference with prospective business relations claims against Nathan from the inception of this action, because those allegations were included in their December 24, 2024 complaint. Plaintiffs did not seek discovery into Nathan's alleged involvement with planting a negative article about Stephanie Jones and the publication of purportedly defamatory statements on certain websites until July 16, 2025, after the statute of limitations for defamation expired, and nearly a year after the publication of the article. Plaintiffs then waited months until after they admittedly learned of the facts they claim were necessary to bring this motion. Plaintiffs attempt to sidestep Rule 16b diligence requirement by relying on the more lenient standard for leave to amend Rule 15a, focusing on an alleged lack of prejudice to Nathan and Heath. And that amendment is not futile, but those considerations are only relevant if the plaintiffs first establish that they were diligent, which they have not done. Even under the more lenient Rule 15 standard, amendment should not be permitted. Nathan and non-party Heath would be prejudiced by the addition of these claims, which would require reopening discovery which has closed, to redepose Jones and depose third parties. Additionally, the claims plaintiffs seek to add are legally insufficient and thus amendment is futile. First, the 1-year statute of limitations for defamation has expired and the proposed claim against Nathan does not relate back to the existing claims. Plaintiffs also failed to identify Nathan's allegedly defamatory statements and when these statements were made as required to plead defamation. Second, plaintiffs' newly contrived tortious interference with prospective business relations claim against Nathan is duplicative of the proposed defamation claim, and the allegations make it clear that any purported interference by Nathan was at least partially economically justified. Finally, plaintiffs' proposed claim against Heath for violation of Illinois Consolidated Chapter 720, the Illinois Eavesdropping Act, is deficient because 1. Plaintiffs have not met the $75,000 threshold for subject matter jurisdiction. 2. Plaintiffs fail to adequately allege the court's personal jurisdiction over Heath. 3. Illinois law does not apply. 4. Plaintiffs fail to plead a reasonable expectation of privacy. And 5. Plaintiffs fail to plead actual damages from the allegedly wrongful recording as required to plead a violation of the Illinois Eavesdropping Act. Hence, plaintiff's motion for leave to amend should be denied. Second subheading, background. On December 24, 2024, the Jones parties filed a complaint against the Wayfair parties. The complaint alleges 8 causes of action. 1. Count 1 for breach of contract of the employment agreement between Jonesworks and Able, the Able Employment Agreement. 2. Count 2 for tortious interference with the Able Employment Agreement against Nathan, Wayfair, and Baldoni. 3. Count 3 for breach of contract of the engagement agreement between Jonesworks and Wayfair, the Wayfair Agreement. 4. Count 4 of the tortious interference with the Wayfair Agreement against Able and Nathan. 5. Count 5 for the faithless servant against Able. 6. Count 6 for the breach of fiduciary duty against Able. 7. Count 7 for the defamation against Able. And 8 for count 8 for defamation against defendants John Doe, 1 through 10. Amongst other things, the complaint alleges that Nathan contrived to plant a negative story about Jones in the Business Insider article called Who is Afraid of Stephanie Jones? The Business Insider article, and that Nathan and the non-party Jed Wallace purportedly acted in concert with Does 1 through 10 to publish allegedly defamatory statements on websites about plaintiffs. On December 31, 2024, Blake Lively filed a complaint against Wayfair parties Heath and others in the action entitled Lively v. Wayfair Studios LLC, the Lively action, for allegedly orchestrating a digital smear campaign against her in retaliation for reporting supposed misconduct on the set of the film It Ends With Us, the film. On February 3, 2025, the court in this action largely adopted the case management plan and scheduling order filed in the Lively action, including an April 18, 2025 deadline for the amendment of pleadings. Footnote 1. The docket entries to the Lively action are prefaced by Lively ECF number. All citations to the ECF number are to the docket in this action. On July 16, 2025, the Jones party served Nathan with document requests for material relating to Nathan's redacted. As of the July 1, 2025 deadline for the substantial completion of discovery, the Jones party had not moved to compel or otherwise claim that Nathan's production was inadequate. Nathan produced additional documents on August 6, 2025, which she designated as attorney's eyes only under the protective order in this action because the new documents included information about her other clients. Footnote 2. Nathan's company TAG and Jonesworks are both in the business of public relations and related services. According to the Jones party, the August production included documents purportedly showing Nathan redacted. On September 5, 2025, the Jones parties deposed Catherine Case, a former employee of Jonesworks and Nathan's PR agency, the Agency Group. Nathan's designated Case's testimony as attorney's eyes only as examination implicated work performed for other TAG accounts that do not concern this matter. The Jones parties claim that Case's testimony evidences Nathan's involvement with the websites. The Jones parties subsequently moved to have this attorney's eyes only designated removed, and the court ordered the testimony de-designated over Nathan's opposition on September 19, 2025. The Jones parties deposed Nathan on September 30, 2025, and Wallace on October 10, 2025. Each denied having any personal involvement in the websites. In a November 26, 2025 memorandum in order, this court denied the Jones party's motion to compel Case to produce further materials relating to the websites in response to a subpoena dated October 17, 2025, the Case MTC order. The Jones parties argued that they sought material in response to the information obtained from the depositions of Case, Nathan, and Wallace. However, the court held that the Jones parties should have issued the subpoena as soon as possible after Case's September 5, 2025 deposition, and the decision to wait an additional 6 weeks before doing so demonstrates a lack of diligence. In response to the Jones party's contention that there would be no prejudice because there was not yet a deadline for summary judgment motions, the court noted that does not mean that the parties are free to continue to issue pretrial fact subpoenas up to the moment of summary judgment. The absence of prejudice alone is insufficient to show the presence of good cause. On October 5, 2025, prior to the deposition in the Lively action, Heath produced a recording of an August 8, 2024 telephone conversation with Jones, who was in London. At the time the call was made, Jonesworks was still representing Wayfair in connection with the public relations crisis developing around the film and in connection with the matters unrelated to the Lively fiasco. During this deposition, Heath explained that he recorded this call with Jones because of increasing concerns over Jones' conduct. On December 8, 2025, the Jones parties moved for leave to amend their complaints to add claims for 1. Defamation against Nathan regarding redacted, 2. Tortious interference with prospective business relations against Nathan arising from redacted, and 3. Violation of the Illinois Eavesdropping Act against Heath for his recording of the phone call with Jones. Subheading 3. Plaintiffs are not entitled to leave to amend. A. Plaintiffs have not shown the diligence required by Rule 11. Plaintiff's motion for leave to amend the complaint should be denied due to their lack of diligence necessary to show good cause to amend pursuant Rule 16 of the Federal Rules of Civil Procedure. Especially egregious is plaintiff's attempt to add claims for defamation and tortious interference with prospective business relations against Nathan arising from redacted. Because plaintiff's current complaint filed on December 24, 2024 already contains allegations about Nathan's purported involvement therein. Thus, the Jones parties knew or should have known about the facts necessary necessary to bring these claims not just months prior to April 18, 2025 amendment deadline, but at the inception of this case. This alone is grounds to deny the motion to amend to add these claims. See Oscar v. BMW. A party fails to show good cause when the proposed amendment rests on information that the party knew or should have known in advance of the deadline. Rule 16 governs motions for leave to amend after a scheduling order has been entered, and thus Rule 16 governs plaintiff's motion. Rule 16b provides that the scheduling order must limit the time to amend the pleadings, and that the schedule may be modified only for good cause and with the judge's consent. The Second Circuit is clear that Rule 16 provides that when a deadline in the scheduling order cannot reasonably be met despite the diligence of the party where the moving party has demonstrated good cause, the court may grant leave to amend the scheduling order to extend the deadline. Parker v. Columbia Pictures, and noting consistent with several circuits, the Rule 16b governs motions to amend after the scheduling order deadline. Rule 16b is well established as a heightened standard because Rule 16 is designed to offer a measure of certainty in pre-trial proceedings, ensuring that some point both of the parties and the pleadings will be fixed. The Second Circuit is clear that Rule 16's standard may not be short-circuited by an appeal to those of Rule 15, as Rule 16 requires a different analysis, an analysis of good cause. If we considered only Rule 15a without regard to Rule 16b, we would render scheduling orders meaningless and effectively would read Rule 16b and its good cause requirement out of the Federal Rules of Civil Procedure. In similar context to the one here, courts hold that although Rule 15a generally is interpreted permissively, the plaintiffs do not enjoy such liberal interpretation of the Rule 16b. Fesky v. MHC Thousand Trails Limited Partnership, denying motion to amend complaint to add a new class representative 4 months beyond the scheduling order deadline after adequacy concerns raised. The primary consideration in Rule 16 good cause inquiry is the movement's diligence. If the party was not diligent, the inquiry should end. Grokowski v. Phoenix Construction. Courts routinely deny leave to amend after a scheduling order deadline where the movement fails to show diligence in discovering the facts or in seeking amendment. The absence or presence of prejudice cannot be used to sidestep Rule 16b diligence requirement. See Parker, noting the good cause standard may not be short-circuited by an appeal to the standard under Rule 15. For motions to amend governed by Rule 16b, although the existence or degree of prejudice to the party opposing the modification might supply additional reasons to deny a motion, the focus of inquiry is upon moving the party's reasons for seeking modification. Johnson v. Mammoth Recreations, Inc. Refusing to find good cause under Rule 16a where party received notice long in advance of the deadline that the complaint did not name all the necessary parties. In other words, a district court may consider other relevant factors aside from diligence, including whether the amendment of the pleading will prejudice the defendant, but the absence of prejudice to a non-moving party does not alone fulfill the good cause requirement of Rule 16b. The moving party must first show diligence. See Kodak Graphic Communications Canada Co. v. E.I. DuPont de Nemours & Co. Holding the lack of prejudice to the non-moving party does not negate the requirement that the moving party act with diligence to amend its pleadings. Despite clear guidance from the Second Circuit, plaintiffs incorrectly argue that the standard of Rule 15 applies for plaintiffs' untimely amendment. It does not. However, even if the plaintiff had timely filed their motion to amend the complaint 9 months ago and within the parameters of this court's scheduling order, which they did not, plaintiff still fails to satisfy the more lenient Rule 15 standard. Under Rule 15, motions to amend should generally be denied in instances of futility, undue delay, bad faith, or dilatory motive, repeated failure to cure deficiencies by amendments previously allowed, and undue prejudice to the non-moving party. Moreover, according to the proposed amended complaint, Nathan's alleged involvement in the publication of false statements on the websites occurred in May 2024, and the Business Insider article was published on August 15, 2024. Yet the Jones party did not serve discovery requests seeking redacted until July 16, 2025, after the statute of limitations had run on any defamation claim relating to the websites, and nearly a year after the publication of the Business Insider article. The Jones party's lengthy and unexplained delay in seeking discovery regarding these issues, which underlie their proposed claims against Nathan in the current motion for leave to amend complaint, further demonstrates their lack of diligence. Plaintiffs concede that they knew about Nathan's alleged involvement with the Business Insider article at least as early as August 6, 2025, when Nathan produced documents relating to this allegation. Yet plaintiff did not move for leave to amend until December 8, 2025, over 4 months after they purportedly learned of this fact. As this court's held in the case MTC order, a 6-week delay demonstrates a lack of diligence. Here, plaintiff's delay lasted over twice as long and is therefore even stronger evidence of their lack of diligence. See Lesnick v. Lincoln Financial Corp. Denying leave to amend where plaintiff provided no satisfactory explanation for waiting. Similarly, plaintiffs concede that they knew about the recording of the phone call that forms the basis of their proposed Illinois Eavesdropping Act claim against Heath as of October 5, 2025. Yet, they waited over 2 months to bring this motion. Again, longer than the 6 weeks this court held evidenced a lack of diligence. Plaintiffs' long-standing pattern of lack of diligence eviscerates any argument they have to show good cause, pursuant to the Federal Rules of Civil Procedure 16, and thus their motion for leave to amend should be denied, and the court should end this inquiry there. On related noted, the initial case management plan and scheduling order was filed by the court on February 3, 2025. Lively, Jones, and Jonesworks moved to amend the scheduling order to extend various discovery dates and the date for motions to compel. Jones/Joneswork did not seek to amend the deadline for amending the complaint. On June 15, 2025, the court amended the scheduling order but did not amend the deadline for the parties to seek leave to amend their complaints. On October 6, 2025, the scheduling order was amended with respect to the expert disclosures and discovery. Again, no amendment was requested or ordered with respect to the deadline for amending the pleadings. Subheading B. Plaintiffs are not entitled to leave to amend under Rule 15. 1. Nathan and Heath would be prejudiced by the late amendments. Although Rule 15 provides that leave should be freely given when justice so requires, amendments should not be denied for undue delay, bad faith, or dilatory motive on the part of the movement, repeated failure to cure deficiencies by amendments previously allowed, undue prejudice to the opposing party, or futility of amendment. Undue delay, bad faith, and dilatory motive weigh against amendment. See Bergman v. Morgan Keegan & Co., Telecom Inc. v. 360 Brands Group. Denying motion for leave to amend for futility and undue delay, which would cause prejudice to the defendants. The failure to show diligence under Rule 16 should weigh heavily against, if not forecloses, amendment under the more liberal requirements set forth Rule 15a2. While a lack of diligence and undue delay are factors, prejudice is considered the most important factor in Rule 15 determination. Prejudice exists where amendment would require significant additional discovery, cause substantial delay, or alter the litigation's nature of the eve of dispositive motions or trial. Block v. First Blood Associates, Adgerbrink v. Model Service LLC. See also McDraw Inc. v. CIT Group Equipment Financial. Affirming denial of motion for leave to amend complaint where the proposed negligent misrepresentation claim would require additional discovery causing undue prejudice to the defendants. Tesker v. Experian Information Solution. Allowing plaintiffs' proposed amendment would necessitate yet another extension of discovery deadlines, in this case to allow the party sufficient time to conduct discovery, causing undue delay to the resolution of the case. Schneff v. Jerome H. Siegel, MD, PC. It is clear that if leave to amend were to be granted, defendants would be prejudiced because discovery is closed. This is true, whereas here, a motion to amend seeks to add an entirely new defendant. Plaintiffs' amendments would require significant additional discovery, further delaying the resolution of this action. For instance, plaintiffs initially asserted a defamation claim against John Doe's. A defamation claim against Nathan would require new discovery on, among other things, whether any of the alleged defamatory statements were true or otherwise privileged, to whom the statements were made, when the statements were made, and plaintiffs' purported damages flowing from each allegedly defamatory statement. At the very least, A. Jones and Jonesworks depositions would have to be reopened. B. Additional written discovery would have to be propounded upon the parties. C. Subpoenas would have to be served upon non-parties, including current and former clients of Jonesworks. And D. Those non-parties would have to be deposed. The proposed torturous interference with prospective business relations claims against Nathan would also require substantial discovery to determine the non-speculative business opportunities that would have been available to plaintiffs and the concrete profits that those claimed future opportunities would have generated. While discovery was conducted on plaintiffs' existing claim for interference with existing contracts, discovery on potential future relationships would open a whole new ballpark of fact discovery on subjects which are irrelevant to the existing claims and thus has not been delved into by any party. For instance, with respect to the Business Insider article, A. Jones and Jonesworks would have to be redeposed. B. Subpoenas for documents would have to be issued to Business Insider as well as to all the sources of information used in the article. For example, the people with whom the author spoke. And C. The authors and anyone who provided information for the article would need to be deposed. Expert discovery would also be implicated on the reasonableness of claimed losses for future business relationships. Finally, Heath is a new party to this lawsuit. Heath would be entitled to the discovery relevant to the new eavesdropping claim and his defenses. For instance, under Illinois law, plaintiffs must prove actual damages from the alleged recording. Thus, crucial discovery, including plaintiffs' depositions, would be required to establish whether plaintiffs were damaged by a single recorded call between Heath and Wayfair's public relation agent, Jones, and the amount of such damages claimed, if any. Heath may also seek non-party discovery from Jones' family members who were in London with Jones and may have been present during the call, destroying any reasonable expectation of privacy, an essential element of the Illinois eavesdropping claim. In sum, the extensive additional discovery that would be required by the amendments long after the close of discovery would significantly and unduly prejudice defendants and delay trial. Subheading 2. The proposed amendments are futile. In assessing futility of amendment, courts apply the same standard as Rule 12b-6 motion to dismiss. Thus, an amendment is futile if it would not survive a motion to dismiss. Lucenti v. International Business Machines Corp. IBEW, Local Union 58 Pension Trust Fund and Annuity Fund v. Royal Bank of Scotland Group, PLC. Where claims are time-barred or legally deficient as a matter of law, amendment is futile. A. The proposed defamation claim is time-barred. New York law provides a 1-year statute of limitations for defamation claims. Thus, if the proposed claim for the defamation against Nathan does not relate back to the complaint, the claim is untimely. The CPLR Section 1024 allows for a DOE substitution on a related party theory after expiration of the statute of limitation party where a plaintiff 1. Exercised due diligence prior to the running of the statute of limitations to identify the defendant by name, and 2. Describe the John Doe party in such form as will fairly apprise the party that he is the intended defendant. Hogan v. Fisher, John Doe pleadings cannot be used to circumvent statutes of limitations. Plaintiffs failed to make a diligent effort to identify Nathan as an unknown defendant prior to the commencement of this action through the date of the statute of limitations expired. There is no evidence that plaintiffs exercised any pre-action due diligence to ascertain the identity of the John Doe defendants. See Robertson v. Florinard, rejecting CPLR 1024 relation back argument, where plaintiff failed to exercise due diligence to identify Doe defendants within statute of limitations and provided no information regarding pre-filing efforts plaintiff may have made to identify proper party. The alleged defamatory websites were published in May 2024. Plaintiffs waited more than 7 months until December 24, 2024 to commence this action. Plaintiffs then waited another 7 months until July 16, 2025 to serve Nathan with requests for documents pertaining to the redacted. Those requests were served after the statute of limitations expired in May 2025. Footnote 4. Although plaintiffs allege they also served subpoenas on the platforms hosting the websites and social media pages, they neglected to attach those subpoenas to their motion, likely because they too were not served in a diligent fashion. See Fallon v. Nassau County, rejecting CPLR 1024 relation back argument where plaintiff made no effort to ascertain identity of defendants before the statute of limitations expired. Walker v. GlaxoSmithKline, affirming summary judgment and rejecting CPLR 1024 relation back argument where the plaintiff failed to establish that he made timely and diligent efforts to discover defendants' identities prior to when the statute of limitations expired. Tucker v. Laredo, Reversing order granting leave to amend, where plaintiff waited 10 months after filing complaint to seek documents concerning identity of proper defendant and waited more than a year after the commencement, long after the statute of limitations had expired, to seek leave to amend. According to their complaint filed a year ago, plaintiffs believe the John Doe defendants acted in concert with Nathan to publish the websites. In other words, plaintiff knew of Nathan's identity and purported involvement with the websites when they filed their complaint in December 2024, but nevertheless waited until after the statute of limitations expired to assert a defamation claim against her. Plaintiffs have not exercised the due diligence necessary to invoke the relation back doctrine. An amendment to add a defamation claim is futile. B. Plaintiffs fail to plead the elements of defamation. To plead a defamation claim, a plaintiff must adequately allege 1. A written defamatory statement of fact concerning the plaintiff. 2. Publication to a third party. 3. Fault, either negligence or actual malice. 4. Falsity of defamatory statement. And 5. Special damages or per se accountability. The complaint must identify the purported communication and an indication of who made the communication when it was made and to whom it was communicated. First, plaintiffs do not attribute a particular statement to Nathan. Rather, Nathan allegedly made or published defamatory statements to at least one other person, and in some cases to multiple persons. Such group pleading is insufficient to meet the exacting standard for identifying the marker of each communication. Luthke v. Seagram Co. Limited, dismissing defamation claim where plaintiff did not specify which defendants made the statements. In addition, with a single exception, plaintiffs have failed to identify the temporal aspect of the statements with the requisite specificity. See Biomed Pharmaceuticals Inc. v. Oxford Health Plans Inc. Defamation claim stating the one statement was made on August 16, 2009, and the rest were made on or following August 16, 2009 was insufficiently pled. The proposed amended complaint identifies only one date when a single alleged defamatory statement was made, but no others. Thus, the temporal aspect of the defamation claim is insufficiently pled, and the claim is deficient. 3. The proposed tortious interference claim is deficient. A. Tortious interference claim is duplicative. In Goldman v. Barrett, the Second Circuit held that a tortious interference claim must be dismissed as duplicative where it is premised on identical underlying factual content as a defamation claim. Where the alleged harm derives from the purported defamatory statements rather than an independent source, the tortious interference claim cannot survive as separate cause of action because claims surrounding in tort are in fact defamation claims, where the entire injury complained of the plaintiff flows from the effect on his reputation. Plaintiff's proposed claim for tortious interference with prospective business relations is duplicative of the defamation claim. Both claims arise from Nathan's purported publishing of false statements on the websites. Most importantly, the alleged harm to plaintiffs from both claims arises from the purported effect on plaintiff's reputation. Because a tortious interference claim against Nathan is duplicative of the defamation claim, amendment to add the tortious interference claim is futile and leave to amend should be denied. B. The tortious interference claim is not pled with specificity. To state a claim for tortious interference with business relations under New York law, a plaintiff must adequately allege that 1. The plaintiff had business relations with a third party. 2. The defendant interfered with those business relations. 3. The defendant acted for a wrongful purpose or used dishonest, unfair, or improper means. And 4. The defendant's acts injured the relationship. First, at the motion to dismiss stage, a plaintiff must specify some particular existing business relationship through which plaintiff would have done business but for alleged tortious behavior. Brown Media Corp. v. K&L Gates LLP, Cambridge Capital LLC v. Ruby Has LLC, dismissing tortious interference with prospective business relations counterclaim where defendant has not identified any specific business relationship with which plaintiff interfered. E. Textile v. Turco Textile, dismissing counterclaim that was pled did not contain sufficient factual material to make out a claim for tortious interference with prospective economic advantage. Plaintiffs failed to specify any business relationships with which Nathan purportedly interfered, referring to a single unidentified mutual client, which is insufficient to plead a tortious interference claim. Next, for wrongful means, a plaintiff must demonstrate that the defendant's conduct amounted to a crime or an independent tort. Plaintiff's allegations are woefully short of meeting the standard. Plaintiffs allege that Nathan engaged in a public relations campaign to plant negative and false stories in the press and on the internet about plaintiffs. This conduct does not amount to a crime or independent tort. Pleading the presence of false statements alone is not enough to support a claim for tortious interference. Friedman v. Coldwater Creek. See also Boehner v. Heiss. No reasonable juror could conclude that plaintiffs satisfy the elements for tortious interference with prospective economic relations merely by showing that defendants said bad things about them. Finally, conduct constituting tortious interference with business relations is by definition conduct directed not at plaintiff itself, but at the party with which the plaintiff has or seeks to have a relationship. Thus, allegations that are directed at the plaintiff rather than a third party could not satisfy the wrongful means element, even if they did sufficiently allege tortious conduct. Conflict International Inc. v. Komarek. Dismissing claim for tortious interference with prospective economic advantage where the alleged acts were not directed at plaintiff's clients. Here, plaintiff's allegations of misconduct are entirely directed at plaintiffs themselves. Nathan is alleged to have carried out a negative publicity campaign directed at plaintiffs. There are no allegations of any conduct by Nathan toward any third parties, including the unidentified mutual client. Therefore, plaintiffs have failed to adequately plead a claim for tortious interference with prospective business relations. This claim is insufficient and the request to add it should be denied. C. The alleged tortious interference is economically justified. A well-recognized defense to a claim for tortious interference with prospective business relations is that the conduct at issue was taken to protect a party's economic interest. When a defendant has acted with a permissible purpose, such as normal economic self-interest, wrongful means have not been shown, even if the defendant was indifferent to the plaintiff's fate. In RBG Management Corp. v. Village Supermarket Inc., for instance, the court dismissed tortious interference with prospective business relations claims where the defendant's actions were motivated by legitimate competitive interest rather than wrongful purpose. Plaintiff's proposed tortious interference claims fails because it alleges that the conduct at issue was undertaken by Nathan at least partly for a legitimate competitive purpose rather than a wrongful one. Plaintiffs allege that Nathan's negative public relations campaign was done intending for a mutual client to terminate his relationship with Jones and Jonesworks, and the mutual client ultimately and as a result did not renew or enter into an agreement with Jones and Jonesworks that he would have but for the aforementioned conduct. Indeed, plaintiffs expressly allege that Nathan's motivations was for Nathan to maintain that client. By plaintiff's own allegations, therefore, the alleged conduct was undertaken for a competitive purpose and to protect Nathan's relationship with this purported mutual client. For this additional reason, the claim for tortious interference with prospective business relations is insufficient and the motion to amend to add this claim should be denied. Subheading 4. The proposed eavesdropping claim is deficient. A. Plaintiffs fail to plead subject matter jurisdiction. Subject matter jurisdiction requires plaintiffs must plead damages that exceed $75,000, exclusive of interest and cost. This amount in controversy threshold cannot be aggregated among various defendants. It must be satisfied with respect to each defendant. Conclusory allegations that the amount in controversy requirement is satisfied are insufficient. Dismissal for failure to meet the jurisdictional amount is justified when, as here, it appears to a legal certainty that the claim is really for less than the jurisdictional amount. See also Tong Cook America Inc. v. Shipton Sportswear Co. A party invoking the jurisdiction of the federal court has the burden of proving that it appears to a reasonable probability that the claim is in excess of the statutory jurisdictional amount. Plaintiff's proposed claim for violation of the Illinois Eavesdropping Act fails to establish to a reasonable probability that Heath's recording of a single phone call would or did cause plaintiffs in excess of $75,000 in damages. In fact, plaintiffs do not claim any damages specifically in connection with the proposed cause of action. Rather, plaintiffs merely allege in conclusory fashion that all their claims in the aggregate exceed $75,000. That is insufficient because the law is clear that plaintiff must satisfy the jurisdictional amount as against each individual defendant. Moreover, plaintiffs do not allege facts sufficient to make damages exceeding $75,000, reasonably probable as is required. Plaintiffs do not allege, for instance, that Heath published, disseminated, or otherwise used the recording in any improper way that would have caused them damage. See Media Logic USA v. Prenova US LLC. Granting summary judgment dismissing Illinois Eavesdropping Act counterclaim for lack of damages where recordings were not published or disseminated in any way. Accordingly, plaintiffs failed to plead to a legal certainty that this claim would support damages in excess of $75,000. B. Plaintiffs do not plead personal jurisdiction over Heath. Footnote 5. A special appearance is not required to contest personal jurisdiction. Soshka v. Mudge. See also Taormina v. Thrifty Car Rental. Granting motion to dismiss based upon lack of personal jurisdiction and failure to state a claim. Plaintiff's proposed amended complaint fails to allege personal jurisdiction over Heath under either New York's long-arm statute or the Due Process Clause. The plaintiff bears the burden of establishing that the court has jurisdiction over the defendant. The proposed amended complaint does not allege that Heath is domiciled, physically present, or personally does business in New York, as required to support an exercise of general jurisdiction under CPLR Section 301. Plaintiff's Illinois Eavesdropping Act claim does not arise out of activities that Heath purposely directed at New York. The alleged conduct on which plaintiff's claim is based did not take place in New York. Heath placed the call from Illinois to Jones in London. While Jonesworks has its principal place of business in New York, personal jurisdiction turns on a defendant's contacts with the forum state, not a defendant's contacts with a plaintiff who resides in the forum. The proper question is not whether the plaintiff experienced a particular injury or effect, but whether the defendant's conduct connects him to the forum in a meaningful way. Plaintiffs do not adequately allege that either prong of CPLR Section 302A3 is satisfied to support an exercise of specific jurisdiction. Plaintiffs argue that Heath is already a named defendant in the Lively matter, but it is well established that participating in other litigation cannot establish specific jurisdiction, which must be based on contacts with the forum related to the claim at issue. Involvement in other cases in New York does not create specific jurisdiction because a defendant's relationship with a third party standing alone is an insufficient basis for jurisdiction, and those other cases create no connection between the forum and the specific claims at issue here. Thus, the claim cannot proceed. See Spiegel v. Schulman, affirming district court's order denying leave to amend where the amendment would be futile because the plaintiffs had failed to demonstrate personal jurisdiction over defendant. C. The Illinois Eavesdropping Act does not apply. Even if this court had jurisdiction over the claim against Heath, the Illinois Eavesdropping Act does not apply. The only hook for the plaintiff's proposed claim under the Illinois Eavesdropping Act was Heath's temporary presence in Illinois when the call in question was made. However, neither plaintiff nor Heath are domiciled in Illinois, and neither are alleged to have any interest in or connection with Illinois. See Golden Archer Investments LLC v. Skynet Financial Systems, applying Illinois Eavesdropping Act to scenario where party in New York reached into Illinois to record a call with party in Illinois and injury was sustained in Illinois, because there is no basis to apply the Illinois Eavesdropping Act here. Adding the proposed claim is futile. Plaintiffs lack standing to bring statutory claim under Illinois law. Indeed, courts routinely hold that a plaintiff is unable to pursue claims based on statutory causes of action created by states where plaintiffs neither lived nor were injured. Zapadinsky v. Blue Diamond Growers, holding that New York resident could not assert eavesdropping claim under California law, even though the defendant was located in California at the same time she illicitly recorded the call. Drake v. Toyota Motor Corp. Holding parties generally lack standing to bring claims under the laws of states other than the ones they reside in. Given that the purpose of the Illinois law is to assure Illinois citizens that their conversations would not be recorded by another person without their consent. People v. Clark, there is no basis to apply the law to a claim brought by plaintiffs who are not alleged to have suffered any injury in Illinois. Looking to statute's purpose to determine the plaintiff is not within the class of persons intended to be protected by the statute. Given that the court lacks subject matter jurisdiction over the proposed claim against Heath and lacks personal jurisdiction over him, and given that the Illinois Eavesdropping Act is inapplicable, the court need not decide whether the laws of the United Kingdom, where Jones was located at the time of the call, New York, where Jonesworks maintains its principal place of business, or some other jurisdiction applies to any claim by plaintiffs for eavesdropping, and whether under that law plaintiffs can state a claim. Footnote 6. See Granite State Insurance Co. v. Primary Arms, LLC. Domicile of LLC for choice of law analysis is where LLC is headquartered. For example, New York law permits conversations to be recorded with the consent of only one party. D. Plaintiffs do not establish a reasonable expectation of privacy. Assuming the Illinois Eavesdropping Act applies, the statute only applies where there is an expectation of privacy. 720 ILCS defines a conversation under this statute as any oral communication between two or more persons, whether in person or transmitted between the parties by wire or other means, when one or more of the parties intended the communications to be of a private nature under circumstances reasonably justifying that expectation. Where there is no expectation of privacy, a claim under the Illinois Eavesdropping Act fails. See Cookoven, LLC, and Mid-Century Insurance Co. No reasonable expectation of privacy, where Duffner called Meyer to obtain information to process plaintiff's insurance claim, and plaintiff has not alleged that it did not expect Duffner to forward that information to other employees at Mid-Century. People v. Johnson. No expectation of privacy, where conversation could be overheard or intercepted. Plaintiffs do not plead a reasonable expectation of privacy because 1. At the time of the call, Jones was with other individuals who could overhear her, and 2. Both parties contemplated sharing, and in fact did share, the content of the call with others. Thus, the Illinois Eavesdropping Act claim is legally insufficient, and the motion to amend to add this claim should be denied. As Jones noted in contemporaneous communications, she was in London with her family at the time that the call was made. On the call itself, Jones stated, "My entire family is here." At minute 6:37 to 6:39 on the call, Jones can be heard speaking with someone else. And at various moments on the call, at 1:35 to 1:50, 10:23 to 10:47, 11:47, and 12:34 to 12:35, other voices on Jones' side of the call, presumably her family members, can be heard. Accordingly, Jones did not have a reasonably expectation of privacy on the call. The proposed Illinois Eavesdropping Act claim fails. Further, the purpose of the call between Jones and Heath was to discuss Jonesworks' role as representative of Wayfarer parties under the Wayfarer Agreement, whether plaintiffs were responsible for a leak to the Daily Mail, and whether or not plaintiffs should continue to speak publicly on behalf of the Wayfarer parties. At various times on the call, Jones indicated her intention to communicate the content of the call with third parties. Docket 193-18. At second 21 to 25, I can call anyone and speak about something they said about Stephanie Jones. Minute 2:54 to 3, I will call Leslie, Blake Lively's PR consultant, and tell her that I heard she said I was leaking things to Daily Mail, and I want her to know that I haven't. Minute 5:57 to 6:09. You cannot take my name and my livelihood and my integrity and say that Sony is accusing me and then try to prohibit me from calling Sony. Minute 12:57 to 13:05. I'm going to let Danny, a Sony representative, know that I did not call Daily Mail. I can let anybody that I want to know that I did not call. True to her word, Jones did in fact discuss the content of the call extensively with other parties besides Heath. The same day as the call, for example, she engaged in an extensive texting thread with not only Heath, but also Abel and Tara Hanks, the latter a representative of Wayfarer parties, that covered who was responsible for the Daily Mail leak, as well as whether plaintiffs could respond to media inquiries on behalf of the Wayfarer parties. The next day, August 9, 2024, Jones redacted. And on August 14, 2024, as she had threatened to do, Jones redacted. Because Jones shared the content of the call with others besides Heath, she can have had no reasonable expectation of privacy regarding the call. Thus, the proposed Illinois Eavesdropping Act is deficient and the motion to amend to add it should be denied. E. Plaintiffs fail to plead any actual damages. Civil remedies for violation of the Illinois Eavesdropping Act are 1. Injunctive relief, 2. Actual damages, and 3. Punitive damages. As noted, plaintiffs fail to plead actual damages, rendering the claim legally insufficient. See Campbell v. St. Jude Medical. Dismissing counterclaim under Illinois Eavesdropping Act, where defendant has not established that it suffered any actual or punitive damages that would entitle it to relief under the eavesdropping statute. Media Logic USA. Illinois Eavesdropping Act counterclaim failed where the defendant failed to identify a plausible basis for an award of actual damages. Notably, even if plaintiffs sought punitive damages, such damages are warranted only in cases when an individual acts with malice, deliberate violence, or gross negligence indicating a wanton disregard for the rights of others, none of which is pleaded or evident from the allegations of the claim. See Loxmandy v. Aero Pneumatics. Claim under Illinois Eavesdropping Act did not warrant consideration or punitive damages where facts surrounding claims were completely devoid of wanton or malicious behavior. Conclusion. For all the foregoing reasons, plaintiff's motion should be denied in its entirety. Signed, Kevin Fritz.
Docket updates. Cut through the noise. Cut through the lies. Come to Docket updates. We give you the filings for you to read in detail.